my experience. Yes, I'm a California licensed attorney. I was not always an attorney. I used to work in the banking industry. I was the guy that used to hire lawyers to sue people for not paying their bills. That's what I did for the banks. And guess what? I was commissioned. I got paid on a commission. I was incentivized. The more money I collected, the bigger my paycheck. Was I motivated to squeeze people for money? You betcha I was. You betcha I was. Back in 1994, I took a position with an investment firm that purchased portfolios of non-performing debt. Much of that non-performing debt was real estate secured. Why would anybody in their right mind buy loans where the borrowers weren't making the payments? Make money. To make money. The difference between what I paid for the loan and the amount of money I recovered, that was profit. How did I recover money? Two ways. First, I look at the value of the collateral. Then I repossess the collateral and sell it. If it's a house, I sell the house. But it generates cash. I get some money. Could I get more money? Possibly. Where would the other money come from? Sue. Lawyer's favorite word. Right? Sue. I'd sue. I'd garnish their wages. I'd empty out their bank accounts. I would put liens on other real property. If they had a business, I'd go after their business interests. And I would force the liquidation of the borrower. Now, naturally, the amount of money I would recover would vary from borrower to borrower. And it would vary depending upon the amount of the debt. Not everybody has a lot of assets, but some people do. And that would come into play, and it would be considered in determining what course of action I would take. The minute any borrower stops making payments on any type of debt, the lender starts jockeying for position. They start asking ourselves, or themselves, what are we going to do to get our money back? And they want as much of their money back as they can get. If you were the lender, you would behave no differently. So, during any short sale, you have to keep that in the back of your mind. That's what lenders do. That's the nature of the beast. They want their money. To think that they don't want their money is what?
Wishful thinking.
A little wishful thinking, a little naive. A little naive. What law applies in this short sale arena? Well, now you know there's a lot of combatants, right? You know there's the lender and there's a creditor. What laws apply there? Contract law. You're dealing with a loan. A loan is a contract. It's a written contract. When you're dealing with real estate secure loans, you're dealing with two types of contracts. Something called a promissory note, another one called a deed of trust. Those are contracts. They're in writing. So naturally, contract law applies. Here's what I want you to understand about contract law. They teach this first semester in law school. A contract is a deal. For purposes of our discussion, it's a deal that's reduced to a writing. It's a written deal. One of the things you learn in law school is once you got yourself a deal, you got yourself a deal. You may say, well, I don't like my deal. That's unfortunate. Because once you got yourself a deal, you got yourself a deal. Why I want to change my deal? I got to change my deal. That's unfortunate. Once you got yourself a deal, you got yourself a deal. Now, what is a short sale? It's essentially an attempt to change the deal. Do you have a legal right to change your deal? No! What's a loan modification? It's a different type of an attempt to change the deal. Whether you're talking about a loan modification, you're talking about a short sale, you're trying to change the deal. Does the bank have a legal obligation?
No.
Generally not. Generally not. They can say no. They can say no. What if they say no? Original deal stands. Is it possible to change the deal? Yeah. Yeah. But it requires what? It requires the bank to agree. The bank has to agree. You, or your client, or the homeowner, and the bank have to agree to the identical change. If you don't have both parties agreeing, original deal stands, no change. You know, the reason I ask questions is that common sense goes a long way with this stuff. Now, what happens if the bank provides you with an agreement, but they don't sign it? Have you guys seen that? With the short sales?
Yes.
Yeah, I've seen it. What did we got? There's something, I know they tested it on the real estate exam, something called the statute of frauds. What's that say? That says any agreement that touches or concerns real property has to be in writing, and it has to be signed by the party against whom enforcement is sought. Meaning, no signature from the bank, it's not worth the paper it's written on. Kind of important to know that. Kind of important to know that. So, the moral behind the story is, the bank doesn't want to work with you, they don't have to work with you. Okay? There's no hammer. You can't run down to the drugstore, buy a hammer, and hit the bank on the head with it to force them to work with you. It doesn't work that way. Second thing I want you to understand relating to loans. Loans. It's it's a contractual principle, but it more has to do with loans. Any type of collateral. This is the general rule in our society, in California, is a borrower's obligation to pay is independent of the collateral. Meaning, if the collateral, regardless of what the collateral is, automobile, house, whatever, if the collateral is repossessed and sold, the sales proceeds are going to be used to pay down the loan, but if they're insufficient to pay off the loan, the general rule is the borrower is obligated to pay that remaining balance. It's called a deficiency. It's a deficiency balance. That's the general rule. Now, there are exceptions to that rule, but the reason I present it to you this way is the homeowner or the borrower is every bit in a position where they're having to find an exception to that rule. If they cannot find one of the exceptions to that rule, then that's unfortunate because they're on the hook for the remaining balance on those loans. Kind of a scary concept. And since we're dealing with real estate secured loans in a short sale, the remaining balance could be quite large. Is this adversarial? Yeah. You betcha. Depending upon the amount of money we're talking about, this can become a life-altering event for the homeowner. Okay? So you got to be mindful of that. So contract law applies. Now I put on there CCP sections, that's California Code of Civil Procedure sections 580B, 580B, and 726. These are commonly referred to as California's anti-deficiency statutes. And we're going to talk about those in greater detail. And those are some of the exceptions that frequently apply that provide some relief for the homeowner as to having to pay the remaining balance on those loans. But once again, if you cannot apply one of these anti-deficiency statutes to the client's case, and no exception applies, then as to that particular loan you're looking at, the homeowner may be obligated to pay. Can you see now how they might become surprised? Who are they going to be upset with if they get hit with that kind of surprise? Whoever's reaching out to help them. Whoever's reaching out to help them. What about Obama law? What about Schwarzenegger law? I like to refer to those areas of law as words of encouragement. That's it. I mean, Obama's now coming out. I saw an article this morning where he's talking about trying to incentivize the banks even further to provide further relief